EGM Network.
Welcome to another episode of From Foster Care to Family Law. This is Susan Chestnut, and I'm with my friend Taylor Hoskins. I learned today that Taylor and I went to the same law school.
Really?
I never got to meet you there, but we both went to the same law school.
Nice.
I've known Taylor for several years now through the community. We both do stuff in the community as activists, and sometimes our paths cross legally. And recently I got to hear you at a conference, and so I wanted to have you on today. So thank you so much for coming on.
Well, thank you for having me. I'm happy and excited to be here.
Mm-hmm. And it's your first podcast,
My
right?
first podcast, so I'm excited and nervous all at the same time.
Yeah,
I'm excited.
It's going to be nothing but fun, though.
Yeah.
One of the things that I wanted to bring you on to the podcast for was because when I was at the conference a few weeks ago, I had almost no idea that this topic even existed, and I feel kind of ashamed. It feels like something that I should know, but
No.
I don't practice your area, so.
No, it's very nuanced, and unless you're practicing personal injury, it's not something that you run into. I only run into it whenever I've got a settlement involving a minor client. So I get maybe 5, 10, 15 a year. So if you don't do personal injury and you don't practice in that realm, you would never run into it. So.
And the other thing is that I was thinking earlier, when you talk about the term guardian ad litem, and that's what we're going to talk about today, in the areas that I practice, it's either about child abuse or it's in a family law case where they're doing a full investigation of the family and they're looking at schools and doctor records and interviewing the family members and going to their houses and things like that. And so this type of guardian ad litem is quite different, isn't it?
Yes. So when I first started practicing, so I've only done personal injury. That's all I've done in my career. And our firm does some nonprofit work with the guardian ad litem nonprofit. And so whenever people were first talking about it, I was like, wait, what? People are going into people's homes to interview the children and make sure the children are being, I'm like, that's not what we do as guardian ad litem. So it threw me off too at first. So in our world, a guardian ad litem is someone who makes sure that the settlement for the minor is appropriate. And they are basically there to make sure that the settlement's in the child's best interest and that the money that they're receiving from the settlement is going to the appropriate place. So a little bit different, because I know guardian ad litem in your world is someone who advocates for the child in front of a judge and who will do home visits or make sure that, there's no abuse or neglect going on with the
Absolutely.
child. And guardian ad litem in my world is to protect the child's interest in a settlement.
Right. Yeah, it is completely different, but somewhat similar.
Mm-hmm.
And is this under Chapter 744?
Yes, it's governed by Florida statute 744. So honestly, I do enough guardianships and minor settlements, but each time I do it, I have to read back through the statute because it's so nuanced. And there's different categories of what you need for the amount of the settlement. So even though I do it a few times a year, however often I do it, I always go back and read the statute too.
I like that. That you should, because they change, right?
And they change.
They change
in
all
Florida,
the time.
they change all the time.
They change all the time. Every July, it seems like.
Yeah.
How does the statute address the financial awards that exceed $15,000 for minors?
So there are two numbers that you have to pay attention to. One is 15,000. If you get a gross settlement for 15,000 or below, or I think it's 14,999 and below, you don't need a guardianship and you don't need a guardian ad litem.
Why is that?
Because the amount that the child's going to be receiving, it's probably only a couple $1,000s. So how we practice, a lot of it is you have to just use your, gut feeling as an attorney. Whenever you sign a minor client, the client isn't the minor, it's the parent or the guardian for the minor.
That's what I thought.
A minor can't bring in action. They're not 18. They can't bring in action in court. So you're working with the guardian or the parent, and you get a feel along the way, if this guardian gets the money, are they going to put it into an account that's going to accrue interest or, something like that. So whenever the minor turns 18, they're going to get a little lump sum of money. Or, are you working with the parent or guardian and you think as soon as this person gets the money, they're going to use it for whatever. And part of the money for the settlement, it's not really to go to a parent for living expenses or school expenses. Like that money is there for the child, for their pain and suffering and their future medical needs. Like that's what that money is for.
Well, that's exactly what the personal injury settlement is about, right?
Right. Yeah. For a child, it's medical care, future medical need, and past and future pain and suffering if there's a permanent injury.
Mm-hmm. And then you said there's 2 numbers that you have to look for.
Yeah. So when you're doing a settlement, there's 15,000 that triggers different things that you have to do. And then 50,000 is the other.
Okay.
So if you get a settlement in between 15,000 and 50,000, it's within the court's discretion as to whether you need to appoint a guardian ad litem. If the settlement is over 50, or if the total settlement of claims is over 50, then you need a guardian ad litem. So like, what does that mean? So a total settlement would be an example of there's a 3-car rear-end car accident, and the person who caused the accident only has 50,000 or 75,000 in coverage. So if the total, and the insurance company is going to say, hey, we're going to tender 50,000 to all of the people that are in the car accident. Let's say there are 5 people in the car accident.
Like as an aggregate settlement, like a whole, just one sole amount for all 3 people?
Right. So if they say, we're going to tender 50,000, we'll figure out how to split it up. Even if the tender's 50,000, and let's say the minor wasn't really injured, they're allocated 50,000, and then the 45,000 split up between parents or other people involved in the car accident, you still need a guardian ad litem because the total amount of the settlement for that car accident was 50,000 or more.
So it's required by the statute. If it's 50,000, it's a shall.
Yes.
Okay. And then I was wondering, are there times in the 15,000, because you said under 15,000, since it's a lesser amount, the court or you, actually the attorney, uses their discretion, but are there times where it's a good idea to have those type of either a guardian or some sort of protected account?
Yeah, absolutely. And sometimes we don't always, like, it's a case by case basis. There are some clients I've had where I've known the parents and I, know that they're going to do what's in the best interest for their child. At the end of the day, you want to make sure when that child turns 18 that they don't come back to you and say, you were my attorney, you were there to protect my interest, and the money that I was supposed to get from the settlement is gone. And so in those instances, some law firms could use it as a normal practice that any settlement they get for a minor, they put in a restricted account. And what a restricted account is, there are several banks around here that will set up a restricted account. It's the money sits in that account, and money does not leave that account unless there's a court order. And so that's until the child turns 18. Then you go petition the court when they turn 18 to release the funds to them.
Mm-hmm. Okay. I just was wondering, what if the child had like special needs or something like that?
Ooh, that's a good question. So in that scenario, what I've had is I've had cases where money has gone into a restricted account, and the child, this is not a special needs, but I think it'll kind of coincide with that. So the child was 16 and she wanted some money out to purchase a car. And I went in front of the judge and I said, this is what we're asking for her to purchase a car. And the judge allowed it, but we had to bring in the receipt for the car that shows that this is exactly the dollar amount that was spent on it. And the same thing with, there was some like back to school things that she needed. And so for certain things you can petition the court for. So if you have like a special needs child and you would like to use some of that money in a restricted account or wherever it is, you have to petition the court. And so at the end of the day, it's the judge's decision as to whether they're going to allow that or not.
I was just thinking of in a scenario like a child is injured, has special needs a special, maybe a handicap accessible type of vehicle to get to numerous doctor's appointment because of an injury, or already was that way before the accident, but now it's exacerbated that they would have access to the account prior to 18 is what you're saying, if with a court order.
Yeah, with if it's in a restricted account, you can petition the court to release certain funds, but you have to have an allocation for it. And I've had cases where the child had a very unique leg injury. And so her parents, they lived over here on the East Coast. Her parents were driving her. There's a child's hospital in Tampa. And so they were driving her there once or twice a month. And so the judge allowed travel expenses out of the settlement because it was part of the treatment that she was getting. In that instance, she already had the leg issue, but then her injury made it worse, I guess. And so it was all part of the settlement. So the judge allowed travel expenses, hotel expenses, and things like that for the parents for taking her over there for the treatment. So it's kind of a case by case, but at the end of the day, if it's in some type of protected account, the judge is the person that says yes or no to get the money out. So
in a circumstance where there is an account that's protected, for example, and you're saying that there is, permission restrictions, you have to go ask and you have to have, I think you said an allocation for it.
Yes.
Are there other reasons for the court to have oversight? Like, I know in probate, like if you do a guardianship, you have to do like a yearly annual report and things like that, which I don't do guardianships. That's one of the reasons, because it's very difficult.
Yeah.
Is that something that has to be done in these type of cases that we're talking about today?
Yes and no. So there's also another category. If the child's getting over $15,000 net, and what net means is,
I wanted to know in this context what that means.
Between net and gross. So I'm just going to use this for easy math. A gross settlement is the total settlement amount. So it's just easy math, 20,000. Total settlement's 20,000. Let's just say attorney's fees are 1,000, medical expenses 1,000, court costs 1,000. So the child's left with 17, and that's the net amount. So the gross amount's 20,000. The net amount's 17,000. If the net amount from the settlement is over 15,000, then it has to have a guardian. And a guardian's different than a guardian ad litem.
Oh.
So a guardian for the money is either their parent can be appointed as guardian, meaning they're protecting the property. And they have to go through, there's like a class they have to take, they have to get fingerprinted. There's like a whole thing that they have to do.
Fingerprinting the parents?
Sometimes the parents do it. It's a long process, but if whoever gets appointed as the guardian of the property, they have to do a yearly accounting. So every year they have to prove with the bank statements, what's in the account. If anything was taken out or added, like if it's in an interest-bearing account or something like that, interest accruing account, they have to allocate for like every penny that's in there. And I'm not going to use the word get around it, but how we get around it, because it can be tedious, is when you put something in a restricted account. If you petition a judge for something, then it's allocated. Like whenever you come back with the receipt, the judge knows exactly what's in that account. And so whenever we set up a restricted account, we sometimes ask the judge to waive the annual accounting, because nothing's going in or out.
That makes perfect sense.
Without the judge's approval. And if something does come out of the account, then they know then and there, what the ending balance is.
That makes perfect sense. But then it also makes me wonder, that makes the court and the court's oversight and some of the other examples that you've given kind of seem unnecessary, What
do you mean?
So if you can put the money into the restricted account and do it the way that you've described it by court order, and then there's a receipt and the allocation is in the court as it's on file,
right? Why
wouldn't it always be done that way? I mean, besides the court resources and things like that, if the oversight's the point.
Just different ways of doing it. You're either asking the bank to guard the money, or you're asking whoever's been appointed the guardian to guard the money and make sure it's being used in the best interest of the child. It just depends. And then a third thing is if you've got a significant settlement, you could put it in a structured settlement so that it's growing. Like if the child's young, like if you've got, a 2-year-old, 3-year-old, 4-year-old, 5-year-old, if they get a large lump sum settlement, you can put that into a structured account or structured settlement so that it's growing while the child's growing up.
Can you do this for me? Can you dumb that down a little bit?
Sure. I'm going to try to.
Because when you say structured settlement, I'm thinking like incremental payments of settlement, right?
And that too. Yeah.
Yeah.
Finance
is that the same thing as what you're talking about, a structured settlement?
Yeah. I mean, finance is not my background.
Mine either. I'm
going to try to explain it the best way I can. So we've had some settlements for minors where they get a large sum, and instead of just giving that large sum to the child when they turn 18, sometimes the parents opt to put it in a structured settlement. So over time, and their interest accruing, I don't know if I'm saying that right, but the money's earning interest while it's sitting in an account, and it'll be set for like 18, they get 20% of it.
Right.
25, they get 10% of it. 35, they get it. So it comes out over time, because a lot of people don't want an 18-year-old to get $200,000. You know, someone that's 18 that gets that, I mean, what's an 18-year-old going to do? You know, cars or whatever, you know what I mean? Right. So it's just another way to protect the minor when they turn 18 and when they get all this money.
It's reminding me of those people that win the lottery and they can take a lump sum or they can take a certain amount for the rest of their life, right? That's what it's reminding me of.
Yeah. I mean, when you're 18 and you get, I mean, a lot of money to an 18-year-old could be $50,000, but when you're getting more than that, I mean, I can't even imagine what I'd do with that money when I turned 18, you know? So it's just one, and a lot of courts don't like it as well. So a lot of courts like the structured settlement. And they prefer that so that the child gets paid out over time.
Well, let's talk about that because I think that's next. So in order to do the structured settlement, you need somebody to approve it first, like the guardian ad litem, right?
Yes.
So what's the process? Because I think I got a little farther than I wanted to, but what's the process? Do you have to petition the court to appoint a guardian ad litem, or can it just be done, you know, you call somebody and they say, yeah, I'll do it, and you just do an agreement, or how does it work?
So you have to get the guardian ad litem appointed. And what happens is you file the petition with the court saying that this is a case that needs a guardian ad litem. And then you outline whoever has agreed. Some will do it pro bono. Some will get paid out of the settlement because it is a court cost or a case cost. So you get the guardian ad litem appointed. They interview the child if the child's of the age that you can interview them. The parents, the attorney who is handling the case, because the guardian ad litem is supposed to be kind of like a neutral person. They get the case file, go through it, and they approve whether the settlement is appropriate or not. And in the case file, there should be the information for the structured settlement or wherever that money is supposed to go, whether it's to a guardian, whether a parent's going to be a guardian of the money, or the bank in a restricted account, or a structured settlement. They look at that to make sure that whatever the agreement is, it's appropriate. They do like a confidential report, and you don't file the report with the court, but you send it to the judge so that the judge can read through it to see what the guardian says, you know, whether they approve it or whether they don't.
Does the guardian ad litem have any participation in negotiating the settlement, or are we talking merely reviewing the settlement as it stands from maybe somebody like you representing the family and then saying, I agree that this is in the best interest? Or is that what?
Yeah. No, the guardian ad litem has nothing to do with the case itself.
I didn't think so.
Yeah. No, so I'll just use this example. Donna DeMarchi, do you know? Donna, her and I do a lot of guardian ad litems like for each other. And so she works for a total different law firm. And whenever she's got a settlement for a minor, she'll send me, like, everything's done. The case has been negotiated. They have the offer, but we can't accept an offer or sign a release until we get court approval for it. So she'll send me everything. She'll give me like the parents' names, the child's name, number. I call them, I talk to them, I review the file, I review the medical records, and then I put in my report whether I think it's appropriate or not. So like I have no involvement with the actual settlement. I just look through everything after it's done, give my report, and that's it.
But when you say appropriate, my mind is spinning because I'm thinking, are you judging it as appropriate, meaning the amount is sufficient to sustain the medical needs of the child, or are you looking at it as appropriate like, what does appropriate mean in that context?
A good question.
Oh,
So appropriate means you take everything into consideration.
mm-hmm.
So all of the liability laws in Florida. So like, what was it, a car accident? Was it disputed liability? Was it a slip and fall? What do these cases typically settle for?
Do you do this for wrongful death as well?
Yeah. I mean, you don't necessarily, so for a wrongful death, you don't need any type of guardian or anything for that. When you have a wrongful death claim, I typically always get court approval for the settlement. You don't have to if all of the survivors agree.
Okay.
Then you don't need court approval to approve the settlement. Typically, our firm almost always does in that scenario. It's an extra layer of protection.
I like the layers that you've been telling me about.
But no, wrongful death, you don't have to get a guardian. No one has to look over the settlement. As long as the survivors of the estate are okay with it, then you're okay with that.
Mm-hmm. So it's kind of like a global analysis that you're doing with all the moving pieces to see.
Right. Mm-hmm. Yeah, it's like what would this case normally settle for? And you want to make sure that all of the complaints of the child's injuries are accounted for in the medical records. You know, typically children bounce back in a car accident if there's no fractures or broken bones or surgeries needed. Children typically bounce back pretty quickly.
I was told they were made of rubber when I was little.
Yeah.
Yeah.
You don't see a lot of ongoing medical needs for just your, normal rear end fender bender with not a lot of property damage. It's the cases where you've got, a fracture that needed surgery. You want to make sure that everything has healed properly. If it hasn't healed properly, that's, accounted for. So every case is different. Right. They're all somewhat the same, but they're all different, if that makes sense. And so you just have to go through all the little pieces that make the case unique and make sure, everything's allocated for.
Somebody was asking me yesterday, how do you determine this? And I was like, well, every case is different. It's a case-by-case basis. And that's exactly true, because every person is different. Everybody's needs are different. Nobody ever has the same experience.
Right.
Right. Is there anything about a guardian that, I know earlier you mentioned a course, but can anyone be a guardian? Does it have to be, and I should say guardian ad litem, because when you say guardian earlier, it could be a parent, right?
Right.
So specifically guardian ad litem, let me just say that. I find in my line of work that most of the guardian ad litems are other family lawyers. Mm-hmm. Is that kind of the trend? Can anybody be a guardian ad litem for the court? Does it have to be a lawyer? Like, can you tell me about that?
So I don't know that answer for sure. But what I will say is you want to appoint a guardian ad litem that's familiar with the type of
I would think so.
settlement that you're trying to get approved, because you want the judge at the end of the day to rely on that person's report. And so if you've got someone who doesn't practice personal injury or who's not even an attorney, I don't know how that judge can rely on their report if they don't have at least some background of the type of case and whether the settlement is in the best interest of the child or not.
I was thinking of that whenever you were telling me that, Donna, and you.
Yeah.
Yeah, because you both do PI, so it only makes sense that you would know what you were looking for and could do that.
Right.
Right.
Yeah, and there are some other attorneys locally that we use too. They're all personal injury attorneys. That's just what we've always done. Right. And you want to make sure the judge can rely on the report too.
Well, I would hope that the person making those decisions knows what they're looking at and what the needs are. I personally, if I was reading medical records, and I would never be able to guess the standard settlement amount for this type of injury. Right. And I'm sure there's a database that I could pay a lot of money for, but, right. I wouldn't know how to evaluate it. So I'm glad for you to tell me that there's some sort of expertise involved in that. Yeah,
and you don't necessarily want, like Donna and I are friends outside of work as well. Sometimes we say, like, we're actually doing a case right now, and we went through the guardian ad litem report, and her and I are going back and forth of what we think is appropriate for the money. So you don't necessarily want someone to just sign off on do a nice report, sign off on it and send it to the judge. Like you want someone to really look at it and make sure that you as the attorney have crossed all the T's, dotted all the I's, but you're also doing what's in the best interest for the child. And it happens. Like we've had a few where, not with Donna, but with other attorneys, where they'll review everything. They'll call us and they'll say, hey, like, what do you think about this? Do you think, maybe they should do one more treatment with their pediatrician or one more follow-up just to make sure everything's okay? And like, then we'll feel more comfortable to sign off. So you want someone that's really going to advocate for the child, because that's what it's for. It's not, to move your settlement along. It's to make sure that the child's protected.
That made me happy, that last part, not just to move it along. I like that. What are some of the challenges that you've had experienced, like that maybe parents face when they're dealing with these types of cases and settlements and that type of thing?
Ask me that again. Sorry.
So the statute, right? The parents have some rights, but then you can override them per se, right? So have you ever had any challenges with that, like dealing with parents in your line of work?
Yeah, of course. Yeah, listen.
You made me ask twice and it's yes, of course.
I know. Well, I wanted to make sure I heard it right, because, there are instances where the parent sees, this may not come out right, but the parent may see it as a payday. And so in some instances, the parents aren't necessarily happy that we have to go get court approval or we have to put it in a restricted account. So you have to kind of educate the parent too that, yes, we're getting a settlement, but at the end of the day, it doesn't really matter when the settlement occurs, because this money is going to be tied up until the child turns 18 anyway. And in those instances, you kind of have to explain the law and explain why we're doing what we're doing and, have that difficult conversation.
I'm imagining a situation where you get one of those aggregate settlement amounts and you don't know what's specifically for the child, where you might have some run-ins. Like, how do you make the determination of, in an aggregate, what goes to the child and what goes to the other occupants of the vehicle or whatever type of accident it is?
So we've had that come up too, where, so we're just going to use mom, dad, and child are in a car, and $50,000 is all that the policy has. So sometimes the insurance company will just tender the $50,000 and they say, you split it up. We don't care how you split it up. Here's 50. It's all going to the same family.
Well, because that's the maximum, right? So they're tendering the max and they're just going to give it to you.
Right.
Right.
So, and I just want to clarify one thing. You can have a higher policy in Florida than 50, but there are policies that are written 25, 50, meaning any one person can get up to 25, but they're not going to pay out more than 50.
For the total accident.
Correct.
Right.
So if you got 3 people in the accident, they pay out 50. The insurance company will call and say, hey, you figure out how to split it up. Here's the 50.
Right.
And you run in ethically as an attorney, can you represent everyone's best interest? Because they're all kind of competing interests.
And that's what I was thinking over here. It's like, because we're talking about the kids.
Right.
And the kids aren't the one that are actually paying the bills.
Right.
So I could imagine as a parent, and even if a parent's injured in an accident, I'm thinking maybe they've been out of work, maybe they're behind on their mortgage, and maybe it is kind of a payday because it's finally a chance for them to put their life back together. Because as a personal injury attorney, I think that it changes your life.
Yeah. No. Yeah. Listen, a good settlement can be life-changing for people. Or even a small settlement can give you a lump sum to get you back on your feet if you're behind in bills or whatever. So when you have that scenario, you just have to evaluate each claim. First of all, you have to make sure that each party is okay with you representing the other one. Typically, when you have a family, it's okay because at the end of the day, it's all going to the same family. But then you look at things on a pro rata basis. So if the kid just has a couple visits with the pediatrician, give them $5,000, split the rest between mom and dad.
And when you say pro rata, you're talking about a proportional.
Right.
Right.
So a lot of the times we get limited settlements in Florida because there's no law that says you have to carry bodily injury in Florida. So you can have a 1020 policy, a 2550, 100, 300, or higher than that.
As much as I want to pretend like I know what that means, I think the 100 is the bodily injury, no, personal. I don't know which ones. One is for the actual car and then one's for the person in the car, right?
So yes. So let's just talk insurance for a minute.
Let's do that because I feel like I learned about this and I know what it is. And I made sure when I became a lawyer that I went and got it started when I worked for DCF and I was transporting children. They made us have the highest policy limits on our car that we could.
Right.
And I've lived by that mantra because then I became a lawyer and I never wanted to not have enough for whatever was needed. Right.
Yeah. So if anyone's listening to this podcast, this is like outside of what we're talking about for the children, this is something that's super important to protect yourself. So in Florida, you're not required to have bodily injury. So what does that mean in a practical instance? You could be driving along in Florida and get rear-ended, and you're only required to have $10,000 in property damage.
That's the minimum. Like that's all you're supposed to have is 10,000, right?
10,000 in property damage and 10,000 in PIP coverage. The property damage, let's just say I'm driving. I've got 10,000 in property damage, 10,000 in PIP, and I rear end you.
Mm-hmm.
So the 10,000 in property damage goes to fix your car. The 10,000 in PIP goes to me if I want any type of medical treatment.
Okay.
So let's just keep using this scenario. Let's say I total your car and your car is worth more than $10,000. If you don't have collision on your policy,
the person that got hit,
yeah. And I only have 10,000, I will give you my company will give you the 10,000, but then you still may have to pay something to get your car repaired.
Right. So if you got 100, I don't, by the way, for whoever is thinking that I might have $100,000 car and you only get 10,000, you're out of pocket 90 to fix your car.
Right.
Oh,
or however much the damage is.
Mm-hmm.
And then when it comes to the injuries, let's say you have a neck and back injury and you want to go for treatment or you go to the hospital and you get stuck with bills that are $20,000. I don't have anything on my policy to cover that. So you just walk away from the accident with $10,000 to cover your property damage, and that's it. And that's scary for people driving around in Florida. So that's the law. That's what you're required to have.
That's the basic minimum.
Right.
But that's not going to take you very far.
No. And when there's a bad economy, inflation, car insurance is one of the things that people start to lower their limits because it's so expensive in Florida to begin with.
I think people do that to lower their deductible.
And that, I mean,
I wish they would flip-flop the deductibles maybe somehow. You know?
No, it's super expensive. It's one of the things that people cut. So when you're looking at your own policy, there's something called uninsured motorist coverage. And if you don't have it, look at your policy, get it. Because if you're in this same scenario, I rear end you, I've only got 10,000 in property damage and PIP that covers myself. If you had uninsured motorist coverage and you've got, I don't know, 25,000 in coverage, you can use that money to pay your medical expenses or your out of work expenses. It kind of steps into the shoes of the person who caused the accident.
So I've always thought about the uninsured and underinsured, right? The uninsured in my mind is the people driving around with absolutely no valid license, no insurance on their car, probably not even registered.
Yeah.
And an accident happens, right?
Mm-hmm.
And then underinsured is the situation that you just described where but yours basically supplements the lack from the other side.
Right. Yeah. Uninsured motorist is that scenario where you can't collect any bodily injury. So the person could have insurance, but they've got no bodily injury coverage. So that's uninsured. And then underinsured is they've got, 10,000 in BI that you could collect, but your medical expenses are 50,000.
Right.
So that's how it's honestly one of the most important things in Florida to have on your policy.
So we were talking about you started listing the policy limits, and you were saying how it plays into the aggregate settlements, I think is where we were talking.
Yes.
How do we get back there?
I don't know. And honestly, I forgot
we were talking about how do you determine how much goes to the child versus, and you said pro rata, and then I think we got to the percentages.
Oh, and I wanted to make my spiel about insurance. So pro rata, pro rata is exactly that. You can, and courts will do this too if you've got a limited settlement and multiple claimants, or, a limited settlement and there's a ton of medical bills that need to be owed, what everyone's due out of the settlement is a pro rata. So you go through and say mom's medical bills are $100,000, dad's medical bills are $50,000, child's medical bills are $10,000. You kind of do a pro rata out of the $50,000 settlement to allocate to each person.
I get it.
Mm-hmm.
Okay. All right. Let's see.
And just to make another point, so like in that scenario, mom would get more of the settlement. Dad would get a little bit less than mom, and the child would
I
get
thought they
less
both
than.
had 100.
Well, it depends on what the policy is.
Oh, okay.
Because in Florida, you can write a 10-20 policy, 25-50, 100-300. So it just depends on what the settlement's for.
Okay. You were telling me that there are some ethical considerations that you have to make when managing awards. And I think earlier, right before we started, you were telling me about a case that you had recently. You want to talk about that?
Sure. Yeah, I can't really get
obviously you can't give names
to specifics and things, but yeah. So recently I was asked to pro bono do a approval for settlement for a minor who was separated from the family during the immigration process. And this is totally outside my expertise of law. But I guess there's a federal claim that you can bring, and the federal government will provide a settlement to the families for the separation. So the attorney who handled it was in Washington, D.C., and the family lives here locally. So they asked me they had no idea how to do the settlement process here. So they asked me to do it. And right now we're in the process. It's actually a very interesting case. So right now we're in the process of doing the petition and getting the guardian ad litem appointed. One of the interesting things that we're running into, Donna and I are working on it, and that'll be public record because she has to get appointed. And not all the documents you file with the approval of settlement is public record,
Really?
unless you file it under a notice of confidentiality.
I was going to say, can't you do a notice of confidential information?
And typically, like the petitions that have the settlement details in it, that's confidential.
Mm-hmm.
But the order appointing Donna won't be. So anyway, her and I are talking because this child is getting a lump sum settlement when he turns 18. So her and I were talking about this the other day, and she doesn't necessarily feel comfortable doing that. But we got the terms of the settlement, and as part of the terms of the settlement, there's a paragraph that says you can't put the money into a structured settlement. So I didn't negotiate the terms of the settlement.
Is that legal?
I would think so. I mean, the claim itself was in DC, so okay. I'm just here to
assist.
But no, it was part of the settlement terms. It must be something to do with the federal government. I don't really deal in that world a lot. Mm-hmm. But it cleared up I'm not going to say argument, the conversation that we had, because really the only option is to either get a parent appointed as a guardian or to put it in a restricted account. And so based on the settlement terms, it's just going to go into a restricted account.
But you don't have a parent, right? They were separated at immigration, right?
They're all together now. This was in 2018.
Okay.
Yeah. So yeah, they're all living in St. Lucie County. So, and child lives with mom and dad. So they're all back together, but that's what the settlement was for. So it's just interesting. Everything's a case by case basis, and you have to evaluate, what's in the best interest of the child. And we didn't even think a judge would allow that lump sum money going to the kid when they turn 18, but it's part of the settlement agreement. So the restricted account is the best way to do it in this case.
Yeah. Well, it sounds like that's all you get to do with it in the agreement already, right?
Right. And it's still protected. Mm-hmm. The child's going to get it when he turns 18, and you just hope that they're, responsible and use that money for good.
It's probably going to go to college.
I would hope
You
so.
know, I mean, you never know.
Yeah.
I think if I had that much money at 18 or any amount of money at 18, it probably could have helped
Oh,
a
yeah.
lot. You know,
College or
people's paths can be very difficult. And
business startup or something,
Mhm.
something where you're
Yeah.
investing in your future or something
Well,
that'll
college
pay out
isn't
later.
everything, is it? No. So since you have been doing this type of law for a while, and now I want to say that you've gotten good at it. I mean, I heard you talk about it. You're very knowledgeable about it. You keep using terms that I don't even really understand, and I know if I'm not understanding, then there's probably someone listening who doesn't. Um, is there anything that you've noticed doing this type of work specifically that you think might could change or needs a little reformation, or have you had any ideas of how things could be done differently? And if so, what made you come to that conclusion?
Mm. You know, I think our court system does a good job of I think they do a good job of protecting the minor's interest. The only thing that I might change would be the 15 and under part of the statute, because here's one thing that we take into consideration when typically the 15 and under is not, it's not a large claim. It's somewhat of a small claim for a minor. But when we're negotiating as attorneys, we look into it as you need court approval over 15,000. And there's a cost associated with that, because if it's not already in litigation, you have to pay the probate fees. And so if you settle for, I don't know, 15,000, 16,000, 17,000, and you have to get court approval, that money's coming out of the settlement. So why would you not just settle it for $14,999.99, so you don't have to pay the court costs and you don't have to get it approved? And so there's
smart.
There's some like legalities of, you know, I don't know, could you argue that maybe there shouldn't be a court cost for a minor settlement because you have to get it approved?
Sitting in this chair over here, yes.
Right.
I feel like that should not be at a cost to the minor from their future settlement that they can't touch. And for some reason, you know, I mean, I understand the reason, but I don't understand taking it out of the settlement. I know, I get it that somebody has to pay for what's being done, but at the same time, it's like you're taking away from what they actually need.
Right.
If the settlement is truly for pain, suffering, injury, medical stuff, right?
Right. And you have to get it approved when it's over 15,000, so that cost is, and it's like 400 and something to 426.
Is it like a filing fee every single time?
It's a filing fee to open the probate case.
Right.
It's around $400. I mean, it's not.
That's what the divorces are. They're for something. They're exorbitantly expensive, even for people that can't financially afford it.
Right.
Yeah.
And so, like, for instance, in the probate or the pro bono case that I'm doing right now, we're all doing it pro bono, and Florida Rural Legal Services is paying the filing costs, because we want all of that money to go to the minor. We don't want to take out for, you know, guardian ad litem fees or court fees. So we're trying to do what's in the best interest for the child. But that would be the only thing I would change. You know, the having to pay the filing costs, and then, you know, do you make court approval necessary for all, so that every minor's settlement is being looked at by a judge and approved, so that, you know, I mean, there could be some attorneys that want to settle it for $14,999 so that they don't have to get court approval. They can move through the settlement pretty quickly. They get their fee and costs, and the minor's left with whatever they're left with. At the end of the day, was that really in the best interest for the child? I mean, no one else has looked at it. You just kind of have to
sound like it.
Take the attorney's word for it. So I don't know. Like, there are different things that...
There's probably pros and cons to both.
Yeah.
But it would seem like if it's a minor and the minor has no income, and you're taking away from available, I don't want to call it income because it's not earned, but it still is a source of income from the settlement. It just seems like you're taking away from them to give to them.
Yeah.
Right?
Yeah. It's
it doesn't make any sense.
Yeah, it's a weird.
I think they should waive it for minors.
I agree with you, but
I don't know how you make that change. You seem like you're going to go into politics one day. Not I, said I. So maybe you can take that up. Is that on your agenda?
It is on my radar.
Yeah, because I was looking and I was like, oh man, president of the bar, on the board of, Boys and Girls Club and all those things that you're doing. I think you do like that.
I like to be very involved in our community, and I grew up here.
6th generation, right?
Yeah. 5th generation.
Fifth.
Lived here, work here. My dad lived here, works here. I just like to give back to our community in a good way. I mean, I'm like a product of it, and I'm very proud of that. And so I like to, I like to keep trying to make things better here.
And this is your home, right?
Yeah.
And if it wasn't, you wouldn't have come back after law school.
Yeah, exactly. Yeah. Fort Pierce is not really the place that you find your final destination in life, but I love it here. I do a lot of work with the Boys and Girls Club and children. And, I think it's important to give children what they need to succeed in life. And so a lot of my time outside of the office is spent with that.
I honestly think that's how you and I connected the first time, was outside of legal and more in the community, honestly.
It's possible. Yeah, I know we're both out doing a lot of different things.
I don't think that I met you in the whole lawyer pretentious land that we have to live in all the time. Like, I think I got to meet you like as a regular person out helping, doing, and I love to see it. I love it.
Yeah, I enjoy it. I'm sure you do too. It's, I love what I do, but I really enjoy, like outside of work, all the different things that I'm involved in. And politics that may be a thing in a couple of years. We'll see. Yeah.
So if anybody needed to talk to you about, does this qualify for a guardian or any type of legal issue with personal injury or anything like that, how would they get a hold of you?
My email, Taylor, TAYLOR, at htllfirm.com. Our website, hoskinsandturco.com. You can visit that. Call one of our offices, 772-464-4600. We're happy to look at any type of minor settlement that you have, any questions you have about something like that. If you're thinking about pursuing something or anything in the personal injury world at all, we're happy to chat with you about it.
Good. And this is where I was going to end the podcast, but I remember from the conference that you actually are in need of people to become guardian ad litems for the minors. Do you want to talk about that real quick before we close?
Sure. Yeah, So Judge Levin in St. Lucie County needs guardian ad litems. To be honest, I don't know exactly which guardian ad litem he's talking about. Like we talked about in the beginning of the podcast.
I think he was talking about yours.
I know that from our perspective, I call on a handful of attorneys to do guardian ad litems, and I'll give them some shout outs. Donna DeMarchi does them. Steve Simon does them. Andrew Schultes has done some for me. So, there's a limited, because it's time consuming, and a lot of us, there are some cases where there's not enough money to get paid as a guardian ad litem, which is fine. None of us are doing it for the money to be guardian ad litem. But yeah, there's a limited amount of resources for that. And these are just the ones that I know of. And if Judge Levin is asking for it, that means he's seeing a lot of minor settlements, maybe pro se settlements with parents that don't know that they need to get a guardian ad litem. I'm sure there's a list with the court that they kind of go through and just assign. And I'm sure that list is, if I'm a personal injury attorney and I can really only name 3 people that I work with.
That's what I mean.
Yeah. We definitely need more people to volunteer to be
So
guardians.
I want this to be the call to action for that for today, is because this is very important. Making sure that these kids have the money that they need for their injuries and for their futures when they are 18 years old, and it doesn't get spent unnecessarily or whatever it is. And the only way to do that is a guardian ad litem or the restricted account. But even then, you need a personal injury attorney to help you with that, right?
Yeah, you need someone to petition the court if money needs to come out for whatever reason. Then you need someone to do that on the child's behalf.
I'm so happy you came and talked about this.
Thank you for inviting me.
And as hard as I thought this topic was, I really enjoyed this conversation. It does make sense. It does make sense. And especially here you explain it in a little bit lower terms for me than at the benchmark conference. I like it.
It's all, like I said before, I have to read the statute every time because it can be confusing. Like, what is gross? What is net? Like, where does this settlement apply? Like, which version of what I have to get done? Like, what version applies to this settlement? So it's not something that is easy, I guess, and it's not something that you do all the time either because
no,
I mean,
and actually, I've only had one case where this came up, and it was a parent saying there's a guardian appointed on an accident with the other parent. I never got notified, and I had no idea what they were talking about.
Yeah, so as a guardian ad litem, if there are two parents, you obviously have to talk to both of them. You can't really settle a claim unless one parent has full custody of the child and like there's a no contact order, like unless the other parent is MIA and like not in the child's life at all. I get that. But if there's like split custody or something like that, then, both parents need to be interviewed.
Right. As they well should. And that I would advocate for that.
Oh, yeah, of course.
So,
yeah.
Okay. Well, thank you so much. I appreciate you.
Thank you, Susan.
All right. That was so fun.